1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36. And you are not saving your special needs child. All right, we can go off the record. You're going to have to get your life in order. If you don't, your life is going to continue to spiral out of control. But you're an adult. Your son is not an adult. Your son is 100% dependent.
All right, guys. Today we've got a jaw-dropping court hearing featuring Judge Boyd, and she is not holding back. The defendant in this case is a mother accused of leaving her special needs child unattended in a vehicle. On top of that, she reportedly has 2 open CPS cases and continues to struggle with drug-related issues. The facts of this case are raising a lot of questions. At what point does personal accountability come into play? According to the court, this isn't her first opportunity to turn things around either. She's already been given 36 chances. As you watch the hearing, let me know what you think. Did Judge Boyd handle the situation appropriately, or should she have been even tougher? Drop your thoughts in the comments. Now, let's dive into the footage and see how this intense courtroom exchange unfolds. This version keeps the dramatic YouTube narration tone while avoiding overly insulting or potentially defamatory language.
We are waiving any type of preparation period, Your Honor. I believe we have come to a resolution.
All right. Are you the same Victoria Irene Hernandez who was placed on deferred adjudication in 2020 CR 8599 for the offense of abandoning a child with intent to return on January 4th, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right. State.
Yes, Your Honor. Violated condition number 13 on or about the 23rd day of April 2024 in Bear County, Texas. Defendant Victoria Irene Hernandez did then and there operate a motor vehicle without a valid Texas driver's license in violation of condition number 13.
How do you plead to that? True or not true?
Yeah. Waiver the remaining violated conditions.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Is there a proposed agreement?
So there's not.
All right. State, what are you requesting?
State's requesting revocation.
Defense, what are you requesting?
Your Honor, probation had made a recommendation to extend for 1 year, place Ms. Hernandez in a DDRF, followed by mixed supervision and a parenting class. And as the court could see, she was in felony drug court. DDRF was held in abeyance last time as an option, and she is motivated to go to DDRF, be successful in it. Apparently the wait is only 3 to 6 weeks, and that's what we're asking the court to do.
A charge like leaving your child alone in a vehicle for an extended period of time is no small matter. If the intent was to leave and come back later, that's the kind of behavior that can lead to serious child neglect or child endangerment charges, depending on the laws in that state. These offenses can carry significant legal consequences, including prison time. And I know some people will say, I was only gone for a minute. But that's exactly the problem. It only takes a minute for something to go horribly wrong. A vehicle can heat up faster than people realize. A stranger could approach the car, or a child could get out and wander into a dangerous situation. The risks are real, and when a child's safety is involved, just a minute can be all it takes for a tragedy to happen. This version keeps the strong, opinionated tone while sounding more polished and professional.
It has worked. She has been clean since September, and if she was tested today, she's going to come up negative.
Mhm.
So, it's not like she totally... Yeah, there's several things that she did do correctly in felony drug court. There are a number of things, obviously, as the court has seen, that weren't done correctly, but she's made a lot of her appointments, and she has ended up clean, which is the point of felony drug court.
I just don't think you're a good candidate. I mean, felony drug court. I mean, there are major issues, but instead they are still trying to work with you. And they tried to work with you a lot. Here's the thing. I know a lot of people want to stay on probation. They do. Like, nobody wants to go to prison. I don't take any joy in sending the people to prison. And everybody that I send to prison, or everybody I place on probation, I actually do remember them. Even as a defense attorney, I had some clients who ended up in prison. Guess what? I still remember them. and wondering how they're doing, and hopefully they've changed their life. And it'll be the same with you. I just don't think you're a good candidate for probation. I think.
Exactly. Judge Boyd seems like she genuinely tried to give this woman every opportunity to turn things around, but at some point enough has to be enough. We're talking about 36 probation violations or sanctions. That's not one mistake, not a rough patch, and not a simple slip-up. That's a long pattern of poor decisions. Honestly, it's hard to wrap your head around that number. How do you end up back in trouble that many times? Probation is designed to be a second chance, an opportunity to prove that you're willing to make better choices and stay on the right path. Yet somehow, every single opportunity appears to have been wasted. And if you're a parent, especially one with a child depending on you, you'd think that would be all the motivation in the world to stay out of trouble. Most people would be focused on doing whatever it takes to keep their freedom, support their family, and avoid putting themselves back in front of a judge. But according to the court record, the violations just kept piling up. At some point, the court has to decide whether more chances are actually helping or if they're simply being ignored. After 36 sanctions, what is a judge supposed to do? Issue a 37th warning and hope for a different result? You can only imagine what Judge Boyd is thinking as she looks at the history of this case. Whatever decision comes next, it's clear the court has already provided plenty of opportunities. Let me know what you think the outcome will be in the comments below. Now, let's get back into the hearing and see what happens next.
So I was going back and forth with the drug court personnel in this case, and there is some concern if she is given a sentence JSAT.
Oh, it's not going to be JSAT.
Okay. Okay.
All right. And what was the concern though? Now you've piqued everyone's interest.
Judge, they feel that a JSAT sentence is not the reason why she was kicked out of drug court and so forth. They just don't think JSAT would be appropriate. And some other concerns in regards to her child. So if she was given, from my understanding, there is a CPS open case for neglect and possible abuse.
Not on me, on the father.
Okay.
There's an open case.
And state you're asking for revocation?
So we are not opposed to revocation, but we are not with JSAT.
Okay.
Judge, if
I mean,
may.
what I can tell you, I wasn't going to give her judgment satisfied. I just, let me just tell you what my thought processes were.
Yes,
My
sir.
thought process in reading everything was I saw that there's a child involved, right? This case involves a child and it's abandoned with intent to return. So I understand, and I understand that that child, they're telling the report is special needs,
Yes.
but she's making horrible choices.
So DDRF only lasts for long, probation only lasts for long. If we help her continue, she has a possibility of, one more chance. And the court has given plenty of chances before, but if she's given one more chance, there's a possibility that one day she's going to be still with this child, and that child needs a stable parent, and DDRF will help in that potentially.
And you are not saving your special needs child. So where is the child now?
He is with his father at the moment. The CPS case is on the father and the current girlfriend. And
So let me get this straight and correct me if I'm wrong. So you are saying that there's allegations of abuse, and those allegations are abuse against the father who he's with?
yes, Your Honor. And the case has been open for about they opened one CPS case, my court did, because of the what they had found in my phone. And then the caseworker got in touch with
What did they
the
find?
father.
Wait, raise your right hand for me, please. You solemnly swear and affirm the testimony you give will be the truth and nothing but the truth.
Yes, Your
So
Honor.
help you God.
Yes, Your Honor.
All right.
So
State your name.
Victoria Hernandez.
What did they find in your phone?
Like, so later on, they said that it was because like the autism doctor recommended that they lock the door at night. But I thought like they were just locking my son in the room like all day. And so that's what drug court found on my phone when they were going through our messages, was me like getting mad at the dad about locking my son in the room. And so they called CPS for neglect. And then the dad got another CPS case because I believe the school called CPS for neglect as well.
All right, any objection to somebody from drug court zooming in?
Objection.
No objection.
All right, just have a seat. Drug court is going to zoom in so we can get to the bottom of what's going on.
Yeah, I'm not completely buying her version of events. It's hard to imagine a drug court looking at a few text messages alleging abuse and simply saying, case closed. Situations involving child welfare are usually taken very seriously, and claims like that are typically verified through multiple sources, whether it's social workers, family members, school officials, or other professionals involved in the child's life. Then there's the timing. Around the same period these allegations were being discussed, the school reportedly contacted CPS because the autistic child was experiencing issues. That's a pretty significant detail. Schools don't just make CPS reports on a whim. Teachers, counselors, and administrators are mandated reporters, meaning they're legally required to report situations where they reasonably suspect abuse, neglect, or a threat to a child's well-being. So, from where I'm sitting, it feels like there may be more to this story than we're being told. Either there are important details missing, or the situation is being presented in a way that doesn't tell the full picture. Whatever the case may be, the person I feel the worst for is the child, because they're the one caught in the middle of all of this. Let's dive back into the hearing and see what the drug court has to say about the situation.
Her to be around her child, absolutely.
Okay.
And then considering her case that she's on as well. So with that being said, we have seen often that we work with the individuals and there wasn't really enough progress, and we don't feel comfortable with one, probation doesn't like to recommend revocation, but we have seen in drug court that a lot of our participants are getting credit for time served. So we didn't want her to just get a JSAT and be done, because then there's no problems that are fixed. And then we have the concern for the son. So that is very concerning. If I could recommend revocation without the JSAT, I would.
Well, that certainly changes things. At the beginning of this hearing, her attorney seemed very confident in arguing that she had remained compliant throughout felony drug court. But as more information comes out, that narrative appears to be facing some serious challenges. What's particularly striking is the apparent discrepancy between what was initially presented and what the court is now discussing regarding her drug court history and the CPS involvement. If those issues were omitted or downplayed, that's a significant detail in a case like this. And then there's the child welfare aspect. Courts take allegations involving child abuse or neglect extremely seriously, especially when a child's safety and well-being are involved. Once CPS enters the picture, judges are going to want a complete understanding of what's going on before making any decisions. That's why this hearing feels so important. The more details that emerge, the harder it becomes to reconcile the image that was initially presented with the concerns being raised in court. From the outside looking in, there seem to be a lot of unanswered questions. Was this simply an overly optimistic defense strategy, or did they genuinely believe the court wouldn't scrutinize these issues? Either way, it's clear the judge is taking a very close look at the facts before reaching a decision. Let's get back into the hearing and see what comes out.
Let me check. Drug test. Well, she did have a no-show, so to us, that was April the 17th. That is considered a positive in felony drug court. Let's see, her last positive would have been September of last year.
That's all I have for you. Thank you.
Mhm.
All right. And Officer Garcia, you all are not willing to accept her back. Is that correct?
No, Judge. We worked so much with Miss Victoria. And it just seems like we hit a wall at this point.
All right. Thank you so much for zooming in on such short notice. I appreciate it.
Yes, Judge, you have a good rest of your afternoon.
Okay. All right. Bye-bye.
Bye-bye.
Are you still insisting that what was in your phone was not related to you?
I wasn't aware the second time around that a CPS case was put on me. I've been in jail.
No. My question is, are you still saying that what was on your phone?
And I would argue that, she has done several things right. She's also done several things wrong, but there was several things. She did participate in the felony drug program and did a lot of good things. So we want the court to reflect on that.
All right. This is what the court is going to do. Court is going to revoke you. Let me see. Where is the trial court certification?
Handed it to the court.
I do have it here. The court is going to revoke you. The court is going to find you guilty. The court will give you credit for any time served. The court will give you credit if you successfully complete an inpatient treatment, because I see there was some inpatient treatment maybe through alcohol. If you successfully completed that, the court will give you credit for that. And the court is going to sentence you to 2 years in the state jail facility. I'll recommend the therapeutic community. I can't force them to place you in there, but if you going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You're going to have to get your life in order. If you don't, your life is going to continue to spiral out of control. Felony Drug Court is a good program. They work with you for 2 years trying to help you, and you still just want to do whatever you've been doing, which is not good for your son. I always tell people you're an adult. Your son is not an adult. Your son is 100% dependent on you, upon you, and you're just.
After watching everything that unfolded, I'd say the 2-year sentence seems pretty reasonable based on what was presented in court. When someone has accumulated 36 sanctions in felony drug court, it's hard to argue that they weren't given multiple opportunities to change course. At some point, the court has to decide whether additional chances are actually making a difference. What makes this case especially difficult is that there's a child caught in the middle of it all. More than anything, I feel bad for the kid. Regardless of what anyone thinks about the adults involved, children are often the ones who end up paying the biggest price when families are dealing with issues like addiction, criminal cases, and CPS involvement. One thing that stood out to me was the discussion about the child's living situation at the time of the hearing. From what was mentioned, the child was reportedly staying with the father while there were still concerns being addressed. I don't know all the details of that situation, so I'm not going to speculate too much on it, but it's certainly something that raises questions. As for Judge Boyd, I think she handled the hearing the way many judges would when faced with a lengthy history of violations and conflicting information. She appeared focused on the facts presented in court and wasn't willing to ignore issues that had already been documented. But that's just my take. What do you guys think? Did Judge Boyd make the right decision, or would you have handled things differently? Let me know your thoughts in the comments below. If you enjoyed the video, make sure to like and subscribe for more courtroom content. I upload every single day, and I genuinely appreciate all the support you guys show on these videos. Also, if there are any court hearings you'd like me to cover in the future, drop your recommendations in the comments. I always enjoy checking them out. Thanks again for watching, everyone. Take care, and I'll see you in the next one.